So every 10 years or so, Daniel, we get an extraordinary Supreme Court case or Privy Council case which resets the law in a particular area, and we then spend years looking at, and the lower courts examine and try and work out. And we've got one, haven't we, in Broad Idea International and Convoy Collateral. What's it about, and why is it important?
Well, the facts can be stated quite briefly. The claimant issued proceedings in Hong Kong against a defendant, and then went off to the BVI to try and get freezing injunctions against that defendant and a BVI incorporated company said to be controlled by him, and also to get permission to serve out of the jurisdiction on the defendant. The claimant succeeded at first instance, but that was then overturned in the Court of Appeal, which itself overruled the earlier decision from 2010, Black Swan. The claimant went off to the Privy Council to appeal, and the Privy Council ultimately decided against the claimant on the facts, so on the interpretation of the BVI procedural rules. It was held that service out shouldn't be permitted and the freezing injunction shouldn't be permitted, but the Privy Council took the opportunity to reframe the law around both freezing injunctions and injunctions more generally, departing from the previous House of Lords authority in the 𝘽𝙧𝙤𝙀 and in Mercedes-Benz.
So there's 2 points, aren't there? There's the narrow point about interpretation of the procedural rule in the BVI.
Yeah.
We don't need to be concerned about that. It's got local interest, and in due course, no doubt that rule will be changed. But there's a broader point about the extent of freezing injunctions which they can be granted, and that was against Broad Idea, the BVI company. But the claim against Broad Idea didn't succeed, did it? The appeal was dismissed on that count.
The appeal was dismissed on the facts, but Lord Legate took the opportunity at the invitation of the appellant to reframe the law, and he said two quite important things. First of all, on injunctions generally, he emphasised that this is technically an unfettered jurisdiction. He went as far as to say you can have an injunction against a third party, an innocent third party, with no proceedings on foot anywhere in the world against anybody. Technically, it's unfettered. He was quite keen to emphasise, of course, that in practice there are principles that have developed which limit the court's...
So the old idea that we had going back to the 𝘽𝙧𝙤𝙀, and I think I remember reading it at university, that there needed to be a substantive cause of action, and that a freezing injunction was only granted ancillary to the substantive proceedings of the jurisdiction. That's all gone.
That's gone. I mean, that was never the case for many other forms of injunctive relief. Think of things like Chabra and Norwich Pharmacal. But yes, in the case of freezing injunctions, Lord Legate was very keen to emphasise that the 𝘽𝙧𝙤𝙀 had really taken a wrong turn. What had happened was Lord Diplock seemed to have transplanted his own analysis of American cyanamide into the context of freezing injunctions, but freezing injunctions are very different to interim relief, whereas interim relief is to hold the ring pending trial.
But this is all obiter, isn't it? So this is, okay, he said all these things. One, it's obiter, and two, it's Privy Council. So two good reasons why it's not binding in this jurisdiction. Is it going to be influential? Are the lower courts going to follow it here? Do we think?
Well, it's obiter, but it's a very strong. It was a 7-bench Privy Council. 7-justice bench of the Privy Council. So it's a very strongly reasoned judgment. I mean, in terms of the practical implications here, it's going to be limited. We've got Section 25. Section 25 means that in practice.
This is civil jurisdiction judgment.
Civil jurisdiction judgment. Yes, the 𝘽𝙧𝙀𝙀 has been essentially sidelined, but it's going to be of relevance, I think, in two ways. First of all, there are jurisdictions which currently do not have an equivalent of Section 25, or jurisdictions where Section 25 won't help you in England because they're not actually signatories to treaties that allow you to get through the statutory gateway. And secondly, it's reframing the law of injunctions. It's giving us a new jurisprudential basis for the entire law of injunctions. And
so let's then look at it so far as in this jurisdiction is concerned. Given Section 25, it's got no advantages over Section 25. Indeed, arguably, Section 25 is wider. Yeah. But in other common law jurisdictions that don't have an equivalent of Section 25, we know BVI, for example, does know, but there will no doubt be others. Mm-hmm. In there, this could be important.
Absolutely, yes.
And how is it going to apply there? For example, what are you going to need to show so far as the prospect of a judgment in a foreign jurisdiction is concerned? Presumably we get into questions of foreign law, do we?
One would imagine that expert evidence is going to be crucial, but you're right, it's one of the practical questions going to have to be worked out over the next few years as this is tested. How exactly do you go about demonstrating a real arguable case that you will get judgment in a foreign jurisdiction?
And there may also be a question, I'm not very clear about this looking at the judgment, the extent to which you need to show that proceedings in a foreign jurisdiction are likely to happen.
I mean, you would imagine that possibly an undertaking that you will issue, for example, would be one way around that. But again, it's another practical problem that's not really grappled with in what
I mean, one of the other things I was interested in, it's all framed in terms of a money judgment.
Mm-hmm. Yeah.
But what happens, for example, if the proceedings aren't really about that? Say there's the equivalent of Section 423 about setting aside a transaction at undervalue. It's not ultimately a money judgment claim. There must be a question, mustn't it, whether it should apply in that situation too. It would be difficult to say. One would think it ought to. So the restriction to money judgments looks on the face of it a little odd, doesn't it?
It does, and part of what's interesting here is this shift in judicial mood towards a more expansive, more liberal approach to granting injunctions in aid of proceedings. So, as you say, one would imagine that the courts will now be more receptive to arguments that perhaps it should be extended even further.
The other thing that occurred to me was, what about a case where this freezing injunction is sought at the outset to prevent a fraudulent scheme happening? So, in that event, it's contemplated, and if successful, that there won't be any substantive proceedings in any jurisdiction at all.
And in fact, the effect of granting it may be to mean the cause of action never arises. You tip off the fraud so it doesn't commit the fraud.
Indeed. Now, it would, although that would seem to go beyond what Lord Leggatt set out, that there's a couple of really important paragraphs in the middle of the judgment,
101 and 102,
which helpfully summarise everything. So anyone listening to this, no need to read all 80 odd pages of it. Just read those two paragraphs. But again, it looks as if it's limited to cases in which there is going to be substantive proceedings somewhere, but the underlying theme, as you've just mentioned, is to broaden the scope of the freezing injunction jurisdiction generally.
And indeed, as I say, signals probably a more liberal attitude towards all forms of injunctive relief. So we may see an expansion in other areas as well.
So that means, doesn't it, that although on the specific question of freezing injunction in aid of foreign proceedings in England, we don't need to worry about it because of Section 25. Nevertheless, the approach to freezing injunction and the underlying jurisprudential basis of it could be influential in widening the scope of circumstances which even domestically freezing injunctions could be awarded, do you think?
That seems very likely. And one other interesting question is whether this is in fact going to result in more forms of injunctive relief coming into play. We've seen, for example, in Cartier, the Supreme Court quite recently grant the first website blocking order against an innocent internet service provider. Yeah. This more liberal approach, I'm sure, is going to lead to more creative arguments at least being deployed in the courts, and we may see the injunctive jurisdictions expand further.
Because it's not just the Privy Council saying, we want to broaden the jurisdiction. They've set out quite clearly the basis of it, which is we will grant a injunction in an appropriate case if to do so will help assist the court's enforcement process. So if in principle someone is present in the jurisdiction, amenable to the court's enforcement process, it will do what's required in an appropriate case to make sure that if judgment is eventually obtained, it will be effective and can be enforced, and that there are assets here to deal with it. So that's a pretty broad basis, which ought to cut through some of the particular rules that we will see in Norwich Pharmacal and Bankers Trust and Chabra and areas like that. One would have thought.
It feels like we're moving away from quite a technical rules-based approach towards a much more generalised discretion almost on the part of the courts. When that's a welcome development, remains to be seen. But
I had just one final thought about this, and it really goes well beyond freezing injunctions. For me, what was fascinating about this whole thing is, firstly, a very strong court, seven judges, president, deputy president, master of the rolls. Secondly, split 4-3, but split 4-3 not really on the basis of the underlying principles, but rather on the basis of what the Supreme Court's role is. Given its all obiter, the majority, led by Lord Leggatt, again, interesting development as we've seen in recent times. Instead of 7 different judgments, we've just got one judgment, the majority, one of the minority. Lord Leggatt saying, although it's obiter, I am going to set out the principles and the underlying basis of this, although I don't need to do so strictly for the facts of the decision. And then the minority, judgment of Sir Geoffrey Voss, saying, I'm not disagreeing with any of that, but I don't think that's the court's role in this case. So a clear majority, if you like, stepping up to the mark perhaps and saying, look, the role of the Supreme Court here is to give guidance for the future, is to help developing the role. So it'll be interesting to see whether that approach is carried through in subsequent cases, won't it?
Yes, it's almost a reframing of the approach to the common law, one might say, but that's far too big a topic to get into here, so we should probably leave it there.
We'll leave it at that. Thanks so much. A very interesting discussion.